Hi, my name is Rebecca Winterscheidt. I'm a partner at the law firm of Snell Wilmer, and I'm co-chair of the Labor and Employment Group here at the firm. If you're a federal contractor or subcontractor, there are some very important changes that are going to take place on March 24th, 2014. If you already have your affirmative action plan for this year in place before that date, then you can wait for another year until you comply with these new changes. However, if you don't have your plan in place by that date, then you're going to have to comply. There's two areas that are going to be impacted. One is dealing with the disabled, and the other one is with veterans. There's a lot of changes in the disabled area. For example, you now have to ask applicants to self-identify as being disabled. In the past, if you'll recall, under the Americans with Disabilities Act, you were prohibited from asking applicants about their disability status. Now, as a federal contractor or subcontractor, you're actually required to do that. But in addition to asking the applicants about their disability status, you also have to make that inquiry again after you make the offer and before you start employing them, and then again after they start their employment, and then yet again within 5 years of the date of employment, or sooner if their disability status changes. The government has established a hiring goal or utilization goal of 7% for the disabled. If your company has 100 or more employees, though, that 7% goal is going to be applied against each job category, not the entire establishment. The new rules also require companies to ask individuals to self-identify at the application stage if they are a protected veteran. There's also a hiring goal for veterans, and that amount is 8%. However, regardless of the number of employees that you have, that 8% is applied across the entire establishment. So there's several things that you need to be thinking about as that March 24th, 2014 deadline looms. One of them is, do you have to have an affirmative action plan in place? And if so, are you going to have it in place by March 24th? Secondly, do you have the infrastructure set up so that you can collect the data that you need and then later utilize that data in your reporting to the OFCCP? If you have any questions about the upcoming OFCCP regulations that take effect March 24th, 2014, feel free to give myself a call or any other member of the Labor and Employment Group here at Snell Wilmer. Thank you.